The thing that I wanted to talk to you about today is really being prepared for your case and not waiting to the last minute. And the reason I bring this up is because in the last few weeks, I've had a flurry of potential new clients call the office freaking out because they had trials set like in the coming days or weeks. And it put me in a position that I don't like to be in, which is having to say to somebody, I can't help you. I can't take your case. And I hate being in that position because I love helping people. So the thing is, when you get a trial set, there's a lot of things you need to do to get ready. First and foremost is calendaring and docketing, which we talked about. You have to calendar that trial date, and you have to be mindful of how you compute time in your jurisdiction, because that may differ depending on the number of days that we're talking about, in deadlines. So deadlines less than 10 days, for example, in Arizona are counted differently than deadlines that are more than 10 days. It's a difference between counting weekends or not counting weekends. So the first thing when your judge sets trial, you got to calendar that trial date. And when your judge sets trial, there are probably deadlines associated with that trial. So I'm lucky because in Arizona, when judges set trial, they put those deadlines right in the minute entry where they set trial. So it makes it easy. I just lift those deadlines from the minute entry and I put them in the calendar. Other jurisdictions, you may have to go to your rules and see what, the rules say, because many rules say, for example, 30 days prior to trial, you have to do X, Y, Z. 60 days prior to trial, you have to do A, B, C. So if the rules aren't right in your minute entry, then you have to go to your rules of procedure and look at what the deadlines are and calculate those deadlines. The deadlines you have to be mindful of are disclosure deadlines and discovery deadlines. So I was, talking to somebody who was representing themselves recently, and that person was very surprised because they thought that the first and the only time that they had to provide the other side with their exhibits and their evidence was just prior to trial when they were exchanging the pretrial statement. I'm glad we talked through this because that is a problem. Your ex or the other party is entitled to disclosure way in advance of a week prior to trial or when you're exchanging things for purposes of trial. You need to disclose early and often the information that you may use at trial, because if you don't disclose it, then there's a good chance you're not going to be able to use that information at your trial because it was untimely disclosed. I tell people, in my mind, it's better to over-disclose than to under-disclose. And I've made this mistake in my past, and that is to say, I don't think I'm going to need that. Like, we're not going to use it, so we're not disclosing it. Then I get a week before trial, and I think, dang, I wish I had that document because now I need it. So I always over-disclose because I'd rather have more options than I need as opposed to not having the options that I want when I need them. You got to disclose. So calendar your trial, calendar the deadlines, and then you got to follow the deadlines. Now, one thing that's really important is prior to trial, you're probably going to have a pretrial statement due, probably going to have to exchange the exhibits you're actually going to use at trial with the other side. You're probably going to have to provide the exhibits you're going to want to admit to the judge or the judge's assistant. So those are really important deadlines too. In Arizona, if we are not on time with giving a pretrial statement or giving the judge's assistant the exhibits we're going to use, it really could bite us. We have strict timelines to prepare our cases in court. For example, I had a case last week and we had a half hour to present the whole case, 1/2 hour. And then also last week I had another case and we had a total of an hour. So if you don't submit your exhibits in advance and the clerk is forced to mark those exhibits while you're in court, in Arizona, sometimes that means you're getting that time deducted from the time that you should be presenting your case. So that's one way it could hurt you. Another way it could hurt you if you don't submit this stuff in time to the judge is the judge could just say, no, I'm not admitting it. I'm not considering your pretrial statement, and you're just out of luck. So, I know a lot of people out there who are representing themselves, they feel lost, they feel overwhelmed, and I've been in that position myself with certain aspects of my business, but you have to get informed. But even for people who watch Command the Courtroom and they've gotten themselves informed, I fear that they wait till the last minute, and that puts unnecessary stress and pressure on you, and it leads to a lot of these things right here, right? Gray hair, probably losing hair, and wrinkles. I can see that I've got these two like worry lines, and my husband always tells me like, listen up, you always got your forehead like, you're worrying all the time, but really the sooner that you can start preparing your case, the better, and the better job you can do putting it together. Tenacious Warrior says we have a few here that put you on a waiting list before they can even do a consult. And during my busier times, sometimes we have to do that. Like we put people on a list, and sometimes I'm just too busy. Sometimes I'm in court. Sometimes I'm on vacation. Yeah. So like the sooner you can consult with somebody, even if you're not going to hire an attorney, if you want to talk to somebody so they can point you in the right direction, do it sooner rather than later. Okay. It's better safe than sorry. I think like if you're going to err on the side of caution. Christine, where is she? She says, my trial turned into a settlement conference. Funny how discovery, disclosure changes everything. And bam, now my ex wanted to settle. So Christine utilized your leverage. And Christine, I think, is going to be on the show at some point with her attorney. Aren't you, Christine? Christine says disclosures can be a powerful tool to get opponents to back down. So Christine knows. Like Christine has taken several of the programs that I offer, Command the Courtroom offers, and I know that she used those with her attorney to really gain an advantage in her case. So Raul says, I always sought legal advice before my hearings, Wendy, and Command the Courtroom. So that's awesome. Raul, do you have anything good to share about seeking legal advice before your hearings? And then Turtle Beach Babe says, and look at, she is a beach babe. I love seeing that picture. She says, everybody should keep a simple journal at least. Glad I've kept mine. So what kind of journal is it that you've kept? Is it to keep track of your deadlines, Turtle Beach Babe, or what are you keeping track of? And then Amy P says, do you disclose everything voluntarily, or is the other side supposed to request? So, it depends on the rules in your jurisdiction. You have to check them out. In Arizona, we do have to disclose voluntarily. You really shouldn't be forcing the other side to request and subpoena and request again. And a person who does that is really subjecting themselves to attorney's fees and costs. Check out the rules of procedure in your jurisdiction and see what they have to say. Charisma Debatey says, can you give tips on organizing notes for court? Charisma, have you taken the 21-day child custody challenge? If you haven't, I would encourage you to do that. So tips on organizing notes for court. So I give a lot of them in the 21-day child custody challenge. This is probably the biggest tip that I can give to you. Well, I always make a script, the questions that I'm going to ask each witness. I make a script of the questions I'm going to ask the opposing party. And I may not follow that script word by word, but it really helps me hit on the areas that are important. And I cross off, when I've covered an area, I cross that off. So I make sure that I don't miss anything that I need to present to the judge. So often in the questions that I'm organizing, I cross-reference those questions with the exhibits that I'm going to use. The exhibits that I disclosed a long time ago, the exhibits that I've already given to the judge's assistant, the exhibits that I've exchanged with the other party or attorney in advance of trial, and I cross-reference the questions with those exhibits. So say, for example, I am asking my client questions about child abuse. And in that area, I have police reports and orders of protection that I want to admit. So next to the questions that correspond, I will write admit exhibit 15 here, admit exhibit 17. And that really helps me stay organized and make sure that I admit the information that the judge needs to hear. Remember that if you don't admit a piece of evidence, then a judge will not consider it. A judge cannot consider it. Only evidence that you admit is evidence that the judge is going to look at. A lot of people think it's enough that they just show up to court with their pile of stuff, or they think it's enough that they already sent all the stuff to the judge's assistant. That doesn't mean that it's admitted or that the judge has considered it. It's only considered once you move to admit it, and you have to ask for that to happen. And depending on what jurisdiction you're in, you're going to have to lay some foundation in order to get evidence admitted. And Tenacious Warrior is saying, do the challenge. And I will tell you, Charisma, if you haven't already downloaded the Child Best Interest Checklist, I offer a discount on that 21-day challenge. And it's a discount from the regular price that's listed on the website. So if you go to commandthecourtroom.com and you download the Best Interest Checklist, you'll get access to the special price. Let's see, and Tenacious Warrior, who's like the queen of organizing, says organizing is a huge factor. Turtle Beach Babes. So what she's saying that she records as dates and occurrences. We record every vocal interaction, calls, voicemail. The journal, now I understand, is more for me, not for something we'll end up showing the judge because it's too lengthy. And journals are important. You know, it's important to document for yourself. I've realized from a personal perspective how important it is to document, because with so much going on in our lives, it's easy to forget. Imagine going to trial a year from now or 6 months from now. It's really going to be hard to remember things. And Tenacious Warrior is saying organize evidence with each witness and organize evidence in regards to each best interest factor, which is a good tip. Thank you. And I think that I delve into that in the 21-day challenge too. So you got to look at each of those best interest factors in the checklist. If you haven't already downloaded the checklist, do it now.